that for me?
I love a DJ. It's
All right, 14th Circuit Court resumes. Please be seated.
This is file number 16-03145 FC, People versus Willis. We're also considering cases 16-02998 and 16-00604.
Oh.
Now, we had an extensive discussion in chambers before coming in here with attorneys for all the parties here. Mr. Willis is represented by two different counsel, and both of them were present for these discussions we've had in chambers leading up to the oral argument here. And the court has also received briefing from both of Mr. Willis' counsel as well as the prosecutor's office. And I'm going to give everybody an opportunity to make any oral presentation if they wish at this time. So it's your motion, Mr. Wilson. So if you have any comments you want to make, go right ahead.
Thank you, Judge. I'm going to be pretty brief. I mean, the court, first and foremost, the court is well versed in the facts of this case. The court has sat through a couple of hearings and certainly the briefing involved in that. So I'm not going to go through that aspect of it. And I know the court is well versed in the particular court rule that we're relying on. And certainly, as we look at the kind of the two tiers, the first tier being the ability to join cases if, and just reading from the court rule, if a series of connected acts or a series of acts constituting parts of a single scheme or plan exist in that particular overall picture. And as our brief, I think, very in great detail explains that if there ever was a series of investigations in cases where the joinder rule kind of was made for, it is these particular three cases. They are so interconnected and interwoven in the various aspects of the evidence that has been obtained and certainly presented at preliminary examination that, to me, we meet that first prong. The other factors, obviously, that the court is able to consider is draining on party resources, potential for confusion or prejudice stemming from either the number of charges or the complexity or nature of the evidence, the convenience of witnesses, and the party's readiness for trial. The court has already, in the Rebecca Blett homicide, made a ruling on the People's 404B motion. So there are certain pieces of evidence from the other two cases that are coming into that case already. I would certainly anticipate, obviously depending on the court's ruling, filing similar motions in the other two. And from the standpoint of, again, this idea of how connected all three of these are in presenting that sort of chronological and timeline to the jury, to me, that seems to be the most logical and the less confusing of it. And certainly also from this aspect that, you know, I know that from the people's standpoint, we're looking at witnesses from out-of-state, expert witness testimony. I know defense is probably looking at some similar issues. And from an efficiency standpoint, which is secondary to the due process part of this, calling an expert witness or a witness from out of state one time to handle all three cases as opposed to three separate cases seems to me make most logical sense again. So from that aspect, Judge, and again, I will rely on the arguments that we made in our brief to the court. Factually, this is a series of connected events. To say otherwise, I think, is not recognizing how those facts really kind of interweave with one another throughout the chronological history of all three of these cases, and certainly for the other relevant factors that I think the court should consider. So for those reasons and the reasons stated in our brief, I'd ask the court to grant the joinder motion. Thank you, Judge.
I don't care who wants to speak first, or both of you do want to speak, or one of you is going to speak. Both of you both have the same position, basically. But either of you are entitled to speak. Who wants to go first?
Well, Your Honor,
Go ahead.
thank you. We oppose the motion to join. These three cases represent three completely separate incidences that happened years apart. They are not related in any way, completely independent. I believe that joining these three cases, although it might serve to the benefit of judicial economy, that should not be the concern in these cases. Obviously, justice and due process needs to be the concern. The confusion for the jury in separating what is substantive evidence in one case and 404B evidence in another is going to be very difficult to keep track of, and I think these cases need to remain separate and independent to avoid that kind of confusion. And we have filed a brief, Your Honor, in response to the motion, and I'll rest on the brief. Thank you.
Thank you, Your Honor. I did file a responsive brief as well. As the court is aware, I've been assigned to represent Mr. Willis on the first case that came in, the alleged kidnapping of MJN. Even though the prosecution thinks that is an integral part of their theory, and it is at this point just a theory, it's factually separate. My case doesn't involve any homicide or any allegations of murder. It did lead to investigation of the Blush and the Herringa case, but we have separate counsel now because of a conflict that the public defender's office had with that alleged victim in that case. So that's why I was brought in. It's always been handled separate, separate filing, separate prelims, separate trial dates. Now, I understand the theory of prosecutor's theory, but we have to be careful because if you join the other facts and the other witnesses and you start adding all this other layers of the onion, so to speak, in my case, I think it's going to be highly prejudicial, as I said in my brief. You know, in my case, we're dealing with simple facts, an alleged victim who was saying she was allegedly kidnapped and then assaulted with a gun, and that's all we have. Now, if you bring in all these other facts of the alleged murders, you're going to. I'm worried we're going to taint the waters to the jury, and the jury's not going to be able to see that the facts were what they are, and it'll be highly prejudicial for my client. That case be, at least my case, not be joined. All three should be joined. I would agree there, but in my case with Mr. Willis, it should be separate, and it should be held differently with a different jury. And because we are going to be going over a lot of facts or a lot of motions about what can and cannot be included in that case, 404B motions, MCL 768, 27 motions. You know, we have prior bad acts, wrongful acts, all those things. We're going to have to litigate all that before we get to the what can come in my case, and I think that's going to take some time. So I'd ask that the court deny the joiner motion for those reasons and the reasons stated in my brief.
Okay. Well, it's your motion, Mr. Wilson, so you do have an opportunity to respond. If there's any further you want to say.
Judge, again, without getting into too much fact specific, because the court has our brief, I would respectfully disagree with Mr. Quartering in this aspect. Two of the biggest connecting factors, in my opinion, are certainly the fact that allegedly the defendant was driving a silver van when that attempted abduction took place, and at the scene of where ultimately MJN jumps from that van, we find
the
ammo, correct, which, although forensically isn't connected to the ammunition discovered in the van after the subsequent search, it is
Same type.
same caliber and same manufacturer. To me, that's a direct connection. And again, interwoven in all the other things that had taken place. So I guess, although Mr. Corder would like to make that case an outlier, it's really that investigation that opens the door to everything else. I mean, if you look at it, that particular incident that leads to ultimately the arrest, that leads to the searches, breaks open the egg, if you will, of both Fletch and Jessica Herring.
Okay, well, thank you. The attorney's asked if I thought I'd be ruling today on this, and I wanted to wait until I heard the oral arguments before I decide whether I would be ruling today. The oral arguments have not really added anything to what the parties have already done in their thorough briefing that I had the benefit of having the opportunity to review before we came in here. So I think I am prepared to rule on this. I want to be clear, I view this as a discretionary matter with the court. The language of the court ruling in that regard is that the court may join offenses. So that's precatory, not mandatory language. And so there are certain things that I have to consider before we proceed with this. And the first thing I have to consider is whether or not these offenses are related. Well, I really, in a certain respect, settled that issue in the ruling on the 404B proffer. The court found that this was part of this certainly could be considered part of the scheme or plan of these three events. I ruled that way on the motion to admit evidence under 404B of other bad acts. And I ruled, I believe that was in the case involving Ms. Fletch, but I made a ruling on that already. So I incorporate my comments from that ruling on the 404B acts into this to find that indeed this is the case that is suitable for joinder of these three offenses. Now, those are not the only factors that the court must consider in making this determination. The other relevant factors are set forth in B2 of the court ruling. We have to consider the timeliness of the motion. The motion I consider to be timely. We have a June trial date for our first trial. One of the cases was just bound over recently, so we don't have a trial date on that. So the motion is timely, or at least 6 weeks out from the trial date. The drain on the parties' resources, that was heavily in favor of a joinder here. The information that was provided in the briefs indicate to me that this is going to be a lengthy trial and it's going to be executed at considerable expense to the county, both in terms of funding the prosecutor's office aspect of this and funding the public defender's aspect of this. And so there's going to be a considerable drain on resources from both sides in this case, as well as the court. I mean, I do have to consider the court's resources also. And this is going to consume a considerable amount of the court's time. And of course, parties are aware that we have a rather significant criminal docket here that we administer, and a docket that is considerably more extensive than comparable size courts. And so that's something that weighs heavily in favor of the joinder. The other thing we have to consider here is the potential for harassment. I don't see any evidence of that one way or the other. The convenience of witnesses certainly would be facilitated by having one trial, and particularly apparently there are, as you've indicated, Mr. Hilson, you're advising me there are out-of-state witnesses, so that's particularly inconvenient for them to come back here, back and forth for 3 separate trials in this matter. So certainly weighs heavily in favor of a joinder for the convenience of the witnesses, the party's readiness for trial, and that's really not anything that burden evidence one way or the other about. The other factor the court has to consider is the potential for confusion or prejudice stemmed from either the number of charges or the complexity or the nature of the evidence. This is where there's a real problem. And the problem I find with this is in the 404B submissions that I've already heard in the case involving Ms. Bletch. If this were a bench trial, this would be a fairly easy decision for me on this joinder issue. I would be joining these cases, frankly. But I am deeply concerned about the burden that we would put on a jury who are not trained in the law by design. That's the design of our system. Who are not trained in the law to go through what are some rather significant mental gymnastics in keeping separate the purposes for which the other acts or 404B evidence would be admitted in each separate case, keeping that separate from evidence that can be used to bear directly upon the guilt or innocence of the defendant. It's a very, very tricky path to walk. I find it's difficult enough for a jury to segregate the purposes of 404B evidence from other evidence in the case when I have a single charge or a single trial. I think it would be a nightmare, quite frankly, for a jury to have to make the intellectual distinctions that are necessary between the 404B material and the other evidence in each case, and recognize that the 404B evidence in one case could be used for limited purposes, but in another case it would not be limited in its purposes. And now we've got three balls that the jury would have to juggle. It becomes something that is, in my opinion, runs the risk of not having a fair trial. And that's the ultimate goal here, is to give the people in the state of Michigan a fair trial, as well as the defendant. And although there are, as I've outlined here, there are a number of factors that weigh heavily in favor of a joint trial, and if this were a bench trial, this would be a joint trial. Because I would have confidence in the trial fact, whether it's me or another judge, to be able to make the distinctions that have to be made because of the complexity of the evidence in this case. I just don't have that same confidence in a jury to be able to make those distinctions that would have to be made in a three-part trial. I'm confident they could in individual trials, but in a three-part trial, I think it's asking too much. And I think it runs too much of a risk of introducing unfairness and perhaps even error to take that risk. So from the court's standpoint alone, believe me, I would love to join these cases. It would make this a much more efficient way to adjudicate these matters from the court standpoint. But I've got to be guided by principles here which are to promote fairness for all the parties. I'm not satisfied that would be promoted by joining this trial, so I'm going to deny the motion. So either Mr. Corey or Mr. Costco need to clear an order to that effect. Now you also indicated to me that you wanted to address the trial date on, I believe it is the case involving Ms. Bletch, which is set in June. One of you indicated you wanted to address, I don't know, do you want to address that now or do you want to address that another time?
Well, the point that we wanted to make, Your Honor, was we still haven't heard from the Court of Appeals with regard to the notes issue, whether or not they're even going to hear it. We're not aware yet. So our concern, I think both of our concerns are that we will not be able to be ready for trial in June. And it really depends on when the Court of Appeals will get back. And when they do get back, assuming if they rule against Mr. Willis, there's still quite a bit to resolve with regard to the Bletch case. And there's currently a stay on that case.
Well, of course, I issued that stay.
Yes.
I can lift that stay. That's no problem. But what you're telling me is you don't feel you're going to be ready to proceed to trial?
I don't believe so.
Trial date that I've established?
I don't believe so, Judge.
Mr. Wilson?
Judge, we had an opportunity to kind of talk in chambers about this, and as much as I want to move these cases along, in particular, because I know the family of Rebecca Bletch has been waiting several years, and they want to start seeing some closure. There are still some things outstanding that we have at the lab at this point. I don't know a timetable yet, and I haven't been able to see it myself or even turn it over to Mr. Hoster. As required by the discovery rules. And I too share a concern that the Court of Appeals hasn't done anything, hasn't given us any indication. They've had this for a few weeks now, and so I'm not sure what the delay is, but we are at their mercy, I guess, and I'm worried that we won't have, at least for me, the guy that has the burden of proof, I won't have enough time to work that through once and if and when the Court of Appeals makes a decision.
Well, the other issue I can see both sides facing is particularly if you've got out-of-state witnesses, is issuing subpoenas, making arrangements, not knowing whether or not the Court of Appeals is going to have a decision for us then, or whether the state can help us. So I appreciate the uncertainty involved in that. And I don't want you to, it's going to be costly enough to subpoena people the first time to have to redo it. It's another burden. Well, all I can say is I'm prepared to try the case in June, but if you're not, I recognize that there are legitimate reasons why you're not. And if the court, if it's the agreement of the parties that we should reschedule this, I will do that. I think probably the best thing to do is to go ahead and reschedule it on the assumption that we're going to get something here from the Court of Appeals in the near future. So I would like to reschedule this at a time parties think they're going to be ready. Are you going to be ready? Can you give me when you think you're going to be ready?
Judge, I'm happy to maybe at some point, either early next week, give me an opportunity to kind of get a hold of the lab, see kind of where they're at, so that I'm not taking a guess in the dark.
Okay.
I don't want to have
next week if you and Mr. House and Mr. Court. Well, actually, Mr. Court, we're going to be trying the case involving Ms. Bletch first. Is that the plan?
I think that's first up on the.
I believe so. Yes.
Then I'll ask that you two gentlemen then look at what you've got to do, and then give me a realistic date as to when I can set this for trial, and we'll get it set.
That sounds fair, Judge. We can do that.
Very good. Thank you.
Thank you, Your Honor.
I need an order then adjourned in this matter from you, Mr. House.
That's fine.
If you would please, and you'll be one of you. Who's going to do the order on the motion to join?
I'll do that, Judge.
Well, they're just same order but different file numbers, yes.
All right. Thank you. Court's in recess.
Thank you, Your Honor.
Can you join us real quick?
No, I gotta figure out.
All right.
But I'll talk to the others, but you don't do done. No, I have to get through everything.
You can just write it and
Yeah.
send it to me if you want. That's probably the easiest way. That way you have to go in.
Sorry if I step over. Just